Sup? How y'all doing? Gotta get back at ya. Today we're gonna talk about that 40 Rector experience. I mean, you gotta peep it. One, from the gate, remember, like it always says, drop down your corporate compliance policies. Download a PDF to your phone, read it over and over and over again. Two, drop down Black Law's dictionary on your phone, the app, so you can relate to how the language that they use in reference to your situation. Three, drop down your contract agreement. Alright? Or your signed city contract agreement, so you'll know what's expected from you, from your employer under the contract. 4, get your representing unions their mission statement. Start with their mission statement, but basically get their corporate compliance and what they're supposed to do for you under their fiduciary. The fiduciary is basically in how they represent you. And if you don't know, I'm about to drop it on you. We're going to talk about 40 Rector, okay? Because I went to 40 Rector. And going to 40 Rector with 237, grievance coordinator, I got there before he did. That's Todd. I got there before Todd got there. But after I got there, here comes the employer and their representative, okay? Here comes their lawyer and labor relations and supervision from the department. All right, now let's move forward. As I'm there waiting for this guy to show up, for Todd to show up, you know when you go to 40 Rector and you go upstairs, you have to sign in. Once you sign in, the receptionist will tell you which courtroom you basically would go in. Okay. Also, while you're there, you will notice coming into the building, there's plenty of little bubbles. Those little black bubbles, those little cameras, especially when you get upstairs. They got you going in and out. They got you in the waiting areas. They got you going through the corridors. They got you going into the courtroom, which is all recorded. Fabulous. We're going to go to the point where that grievance coordinator, Todd, who showed up after we all got there, and once he came in, he's basically telling the opposition, you got this. So he goes up to the receptionist and he signs in, and she tells him where he has to go as far as what courtroom we will be in once everything starts. So then all of a sudden he goes beeline straight to the employer's representative and the labor relations director and supervision, and he's telling them blatantly, you got this. This is your union representative from Teamsters who's telling the other side, you got this. In plain view. Which basically means it shows how they really care about you. I'm not going to say it's everybody. Maybe it could be individuals. It could be individually. But it's basically showing on a professional level, being it individually or the whole entire staff or whoever's under the contract, it's still showing unprofessionalism, period, no matter what you say or do. All right? It still shows a violation of their fiduciary. So basically, when you just telling them right there, what's that? New York Code of Conduct, Judicial Code of Conduct, Part 1200. Yeah, we're back. As I was saying, Part 1200 is basically says what it is that they supposed to do, as they're obligated, and how they must act within the tribunal. Okay? Now, under their canons, lawyers' canons 1, under integrity, it speaks for itself. So, moving forward, I mean, you look at the fact of what he was just saying, and he's telling them. And here's the part that kicks in. The receptionist had to get up out of her seat because she looked me dead in the face, and I'm looking at her and him, and she's like, I can't believe this is going on. She got up out of her seat, came out of her desk area, whatever, went up to him and tapped him on the shoulder and told him, your client is over there. Your client's over there. You didn't even speak to your client or address your client, and you're over here saying they got this. Okay? So let's move forward, because they got it. And your actions are telling them they got it. Well, you basically said what it is, that your intentions. But under your fiduciary, you were supposed to do an investigation, right? Let's back this bus up. You're a litigations attorney. As a grievance coordinator, you're a litigations attorney. So you basically go out and fight for a contract, allegedly. You fight for a contract as a litigations attorney, right? Right. So based on the fact that it's civil service, you know that you must follow civil service laws. Now, here's the clincher. When I told you that a whistleblower is in place and that they violated said law, U.S. Code 42, depriving of a right or privilege, you were supposed to stop it right there, because there's no city or state law that trumps a federal law. U.S. 42 is a federal law under the Constitution, which brought about the whistleblower. Once that whistleblower kicks in, you got the city, local law number 33. You got the state, labor law 740, and then you got civil service, subsection 75B. That's 3. We don't even got to go to the government level. That's 3 right there. But you proceeded to play that dance in the well, because the courthouse is a ship, and where they at and they do their work is within the well. So you wanted to play that game. Not a problem. Go ahead and play the game. Game is, let's stay within Canon's law. Did you stay within your Canon's law? Hell no, you didn't. Why? 1, you was in the tribunal. Being in the tribunal, that court. We're going to go to 3.3 of Part 1200. That 3.3 brings about your conduct within the tribunal. Your conduct. How you act. How you supposed to follow your canons, and you didn't. So let's go to the next one, which will be 4.1. 4.1 will be about your truthfulness. How truthful you were. As an attorney, as a lawyer. Am I going to be truthful? Or, I'm not going to be one-sided with this. Come on, man. Let's go further. 8.3. 8.3 states the reporting of misconduct. So, basically what you're supposed to do is you're supposed to report that the supervisor turned in the instruments. They both turned in instruments that was fraudulent. Those are fraudulent instruments. So their actual complaint was fraudulent, which brings about an impropriety. So that their lawyer trying to submit it in court under a burden of proof. A senior employer's burden. Sorry, you must follow civil service law under Section 75. And under Section 75, you got to prove beyond under your burden of proof, under a preponderance of evidence, okay, a preponderance of evidence that I was in the wrong. Let's go there. The first whistle. Let's go to that first one, where of insubordination, where the lieutenant came in and screamed on the sergeant, and the sergeant got upset and he turned and he screamed. I mean, who the hell are you talking to like that? You have no right to talk to somebody like that. The city of New York does not pay you or any of his employees to talk to their subordinates in that manner. Now, we're going to go to the fact that if I said something like that, you know, as law enforcement, if you out of line, the first thing a supervisor does is give me your book, and he or she is writing it up in their book. They're going to write it in your memo book, and then they're going to also write it in their memo book. You wrote it in your memo book 2 days later. We was in the 124, you could have wrote it in the 124 book. Even the judge said that sounded like you was corroborating. And then you're going to say, oh, I think this way. No, I don't know who wrote it. I don't think the judge said it. I think it's the idiot who wrote it. That's corroborating. Yeah, you made that up. 2 days later. When your patrol manual, your hospital security manual, which is a hospital police or patrol guide, it basically says that all entries within the memo book, the department issued memo book, and also in the 124 book, the log book, all entries must go in chronological order. By the time and write in order. How you gonna write something in there 2 days later? I'm gonna put this in here. What are you, an idiot? Let's move forward. There's that impropriety. That's an impropriety. Period. Done. Finished. Don't want to hear it. You write the instrument up afterwards in the whole 9 yards and trying to submit it, which constitutes violation of your Penal Law Code 175:30. Hold up, you making a punishable instrument? Yeah. 210:45. Offering a punishable instrument for filing on the record with false written statement. Then we're going to go to 175:30. We could go to 175:35. Either way, it's offering an instrument for filing on the record with false written statement. You want to go to 30? 30 means it's a misdemeanor. You want to go to 35? That's a felony. Okay? Then you get on the stand and lie. Love it. 210:40. Perjury on the stand. Your statement. You and the other sergeant. Perjury on the stand. That's a felony. The judge said that she was lying. That's a felony. Something was supposed to have been done there. That's a felony. Let's go to her. The mere fact, I'm writing them up. You writing me up? Yeah, because I gave you an order. You gave me an order? Yeah, did you put me on the clock? A, you didn't. B, did you send transportation as per the patrol guide? What's that? Page 54, paragraph C. All supervisors are supposed to provide transportation. Did you do it? No. This is comical. Yo, this whole case, I am now doing that book. You wouldn't believe how many laws you guys broke. All right. It's a total of something like almost 30 laws you broke. And the key thing is that each individual involved broke several laws. And it would be the standards would be 19500, which is misconduct. And then it would go to 2020 under a corporation, 2025 because you work for the corporation. Then 10500 under conspiracy. Then if you submitted any documents in the whole 9 yards, it'll go to 175.30 or 175.35. Need we go more? Oh, do we have to go to the fact that you're corrupting the government? What's that, 496.02? Come on now. You did submit this document. Yeah, so when it went to administration, then they took it and they sent it to 40 Rector to file on the record. That would be corrupting the government because it went from one agency to another agency. Yeah. And then, let's go to the last one. Let's go to the real last one. Oh, you have these charges of lateness. Well, who caused the charges of lateness? The probationary employee. That would be the hospital police director. The question is, let me do it like that. If you really wasn't doing anything wrong in the whole 9 yards, why would they change the title? It must be hot like fire. Think about it. It must be hot like fire. I don't know. But I'm just going to say that 40 Rector experience, it was a real experience. At one point, brother was like traumatized. Like, whoa, wait a minute. I'm going by this. And they playing a whole new game. Well, take your time out. Slow the pitch down. Just slow the pitch down. Give that 1, 2, 3 count. And just smack the hell out of the ball. You'll catch it. Just smack the hell out of the ball. Learn what they do and what their guidelines it is in reference to the lawyers under their fiduciary. The judge, who's really nothing but a lawyer, under his fiduciary. Okay? Then your employer's administration, how would you say that? Labor Relations Administration, and those who's bringing the charges up against you, and what they did and how they violated any rules, regulations, or laws. The rules and regulations will be under their corporate compliance policy. Their corporate compliance policy has to be followed under state and federal laws, even local laws. You can do this. But my key is just what we're talking about today. Is how Todd takes and thinks that everybody is a dummy. Another officer told me she went to 40 Rector and they had some other lawyer there. And it was a female lawyer, and the female lawyer from Teamsters basically went in there, didn't ask the officer who they was or anything, and went about, well, you're just going to sign off on this, like you're going to plead guilty to this, and that. And she said, well, wait, who am I? The lawyer gave the officer another officer's name. That goes to show you how much they care about you. We're just going to walk in and drop this. No more. It's time to do the homework. You guys need to set up some type of meeting with each other in the whole 9 yards and talk about your situations, or get a hold of somebody. I mean, there was a few people who hollered at me in that, and they expressed their situation that they was going through, and there was a couple of them that's going through some real serious stuff. I mean, like I said, I got this guy's case right here. And his case, I took it apart. It's in 2 pieces. I took it apart. And I got all the stuff where they were fraudulent. When the incident occurred in the whole 9 yards, he wrote it up and they didn't do anything. So they figured they're going to say, well, we're going to sit this one out. Meaning we're going to let it go past the which they would say is statutory time. That's scratched now. Minute they don't take hand to do anything, you go outside and you file outside. New York State Division of Human Rights, New York City Commission of Human Rights, you go outside. Even EEOC, you go and file outside because of the fact these people were working in compliance with each other, or these agencies, such as New York State Division of Human Rights, wherein they delayed the process. Doesn't matter you delayed the process. The contract is already filed. You can delay the process all you want. That makes you negligence in your official duties. That brings to the fact that you breached your contract. That makes you subject to suit as well. Oh, there's a time there. No, there's always a backdoor. There's always a backdoor. You listen to these people that say, "Oh, the equitable tolling went out. It's too late. It's never too late." Why? Because of the mere fact of them breaching or their use of, how would you say, violation of the corporate compliance, violation any city, state, or federal laws, violation of due process. No matter what, you could get them on due process. See, when they violate due process in the whole 9 yards, such as they did in my case, right? That throws everything out. It automatically vetoes it. Under your substantial and substantive right, they're now forced to go onto your God-given side, the live person side. And it throws out all of that straw man stuff. Yeah, it throws that out. So the key thing is you must take your time out. You got the magic chat, these phones. Download the information, read a little bit every day. Read a little, because you got people in employment where they're just going to target you and bully you. And we getting ready to come up with a rough one right now because the city is talking about letting people go because of the amount of money they wasn't getting in, and they waiting on the federal government to give them money. And you know what's going on with the back and forth, the mudslinging back and forth. And the real deal is election time. You got all of this election stuff coming up. It's not just the executive branch, it's that other branch, the lower ones. You got to get a hold of them. But yet and still, you still must do your homework daily. I've been out for a while, but I still do my homework daily. Where I got individuals on certain levels of law, and they're like, "How long you been doing this?" I said, They was like, "How long was you in office at this one?" They said, "Yo, you could have went to school and become a lawyer within 3 years. You're already doing it." Yeah, I know. But when you take that oath, you get back in bed with them. That's the key. Do you want to get back in bed with them, or do you want to just learn what they do? And then use it to your advantage to protect yourself. That's the key right there. That's the key. So on that note, I just wanted to holler at y'all. I hope you got it. Be careful when you go down there because, a lot of times these people who's paid to represent you is not representing you well. So you make sure that they are there to represent you under their fiduciary. You got these individuals, coming from the union, and they're not even following their fiduciary. They're not even following their fiduciary duty, their fiduciary relationship, or the fiduciary responsibility. So basically, you got to learn this and what it is. And like I said, in the Black Law Dictionary, it tells you right there. So when you see the lawyer stepping out of bounds and he's not doing that, drop down that New York's Judicial Code of Conduct. Yeah, see, because what these guys did, that falls under that. Judicial misconduct. Yeah, that's that misdemeanor, right? Caught you, right? Todd caught you and her and the judge, to the point that you violated your canons, and even the judge said, "Well, I'm going to push this through. We'll bring about what? Ultravirus, beyond your powers, because your canons is by the corporation." And if you violating your canons in the whole 9 yards, or you superseding the corporation, what's the first rule of power in the 48 powers of law? Never outshine the master. On that note, you guys have a wonderful day, and I'm out. Peace.